We'll have the teams identify and introduce themselves to begin.
Petitioner 1, my name, that's for Team 29. My name is Aaron Amako Vivo-Ole, A-A-R-O-N. Last name is spelled K-A-M-A-K-A-W-I-W-O-O-L-E, 2 O's.
Petitioner 2 is Joshua, and I have the same last name. I'll spare the court.
Respondent 1 is Jenna Lawrence, Jennalorence.
Respondent 2 is Rachel Heflin, Rachelheflin.
And I'm sorry, your team number again?
28.
28. 29 versus 28. Will there be a rebuttal?
Yes, Your Honor. I'm giving 3 minutes for rebuttal, audibly during the first argument.
And who will be handling the rebuttal?
Aaron.
You. Aaron will be doing it. We'll use your first name. All right. We'll hear from Petitioner.
Mr. Chief Justice, Associate Justices, and may it please the Court, my name is Aaron Kamaka Vivo-Ole, and along with my co-counsel, Joshua Kamaka Vivo-Ole, we represent the petitioner, the State of Olympus. At this time, we'd like to respectfully request 3 minutes be reserved for rebuttal. Thank you, Your Honors. Today, we ask this Court to rule that the Fourth Amendment was not violated by the search conducted by law enforcement, and that Mr. Denolf does not possess a reasonable expectation of privacy under the Fourth Amendment which society is willing to recognize. We would like to examine this, first of all, through the eyes of Oliver v. United States, where this Court set forth a 3-part test to determine whether or not an individual possesses Fourth Amendment rights. They determined that, first, we must look to the framers' intent when they wrote the Fourth Amendment. Second, that we must examine what the location was used for and what it is traditionally used for. And finally, we must examine whether society is willing to recognize this as a legitimate expectation of privacy.
Could you jump to the use of the Cyclops and how some uncommon, not readily available device could possibly give rise to a reasonable legal search?
Absolutely, Your Honor. The question posed is whether or not the Cyclops 237 constitutes an inviolable search according to the Fourth Amendment. We would contend that, that the technology itself does not violate the Fourth Amendment, as it only helps to enhance the ability of the eye to see, and does not provide what the Court determined in Kylo v. United States was sense-enhancing technology. This Court made the distinction between the ability of the naked eye to make an observation and the ability for the eye to see something that it could not otherwise see.
Your eye couldn't see 900 feet away
Your Honor,
without this device.
yes, Your Honor. However, the Court made the distinction in Dow Chemical Company v. United States, as mentioned in our record in Kylo, that when you are able to enhance the picture that is seen, that does not necessarily violate the Fourth Amendment. In that case, they were able to blow up an image and were able to thereby find the evidence necessary for a warrant. What we have in Kylo instead was a piece of equipment that allowed them to see something that could not usually be seen. In this case, heat radiating off a building. In our case, we are not looking at something that the eye could not usually see. Rather, we are merely only bringing it closer, so to speak, that we might better examine it.
My concern, Counselor, is that the police were there on a drug investigation as part of a strike force. They knew what they were going to do. They knew that they were going to bring this technology to assist them in what otherwise could not be done, which is to see inside an open window 900 feet away. Don't you think it would have been appropriate in this case for them to obtain a search warrant before they began their surveillance activities? And if not, why not?
Your Honor, we would contend that they did not need a search warrant, mainly because this was not a search as the Court defined it in Katz. We believe that they were not trying to violate anybody's Fourth Amendment rights. Rather, they were only viewing what was already available and able to be known by the public. And as this Court stated in Katz, what is knowingly made available to the public does not violate the Fourth Amendment.
If I'm standing 100 feet away from you, Counsel, on an open public road with binoculars looking into your bedroom window, observing you in your bedroom, you don't believe that that's a search?
Your Honor, we absolutely do agree that there is a certain added expectation of privacy within the home, and that when an individual, especially when they're in the bedroom, is within the home, that they do gain an elevated expectation of privacy.
Wasn't this RV a secondary residence for Mr. Denolf's family?
Your Honor, we would respectfully disagree. First, we understand that Mr. Denolf, according to our record, we have absolutely no evidence that he has ever been here before in his life. He probably has, but we do not know this for certain. Second, this has not been used as the Comerford-Denolf residence. It has been used by Mr. Comerford and Mr. Bronner for commercial activity.
What commercial activity would that have been, Counselor?
Yes, Your Honor. We know that they have spent the night here, presumably after tending to their plants. But we also find that an individual who possesses 100 tomato and bell pepper plants, unless he has 20 children, is not using this only for private consumption.
But do we know that he was using it for commercial purposes?
Your Honor, it is unclear from the record. However, this is an apparent commercial enterprise. And therefore, if they were looking at it from the evidence that they had probable cause to believe that this was commercial activity.
But if we assume that it's not commercial activity, doesn't that change our view as to whether or not it is a home or not?
No, Your Honor, we believe that that would not change our view. This has not been used as a residence. While it may have been used as a place where one might lay one's head, it does not necessitate that it contains, as Oliver defines a residence, that which has the daily activities of life, which separates.
So are you suggesting that if I have a summer home that I might go to 2 weeks during the summertime, it is not my home because it doesn't have daily activities other than during that very limited window of time?
Absolutely not, Your Honor. We would contend that while you are living there, you are displaying and definitely pursuing the daily activities of life. But within our record, all that we know that they have done here is that on occasion they have spent the night and that they are growing plants here.
But didn't Mr. Denolf's son, if you're suggesting that it is a home if you spend the night, didn't Mr. Denolf's son spend the night, so it was his home that evening?
Your Honor, we would contend that no, this is not a home, and that no, simply spending the night there does not grant it that it is his home. We would contend that there is definitely a lot more to making a place a home than merely a place where one rests your head. A homeless person rests his head underneath of a highway. That does not make it his home.
Whether it's a home or a vehicle, didn't Mr. Denolf have a reasonable expectation of privacy in the RV?
Your Honor, we would contend that he does not. We would contend that according to our record, or at least in terms of making an analogy through our record, it is more akin to a greenhouse than to an actual home. And
It seems to me that in the hierarchy of greenhouse, phone booth that the Katz case discusses, and then the RV, somewhere on that spectrum, certainly the RV is above a phone booth, which has been recognized as having a reasonable expectation of privacy, correct?
yes, Your Honor. However, the court's opinion in Katz, which is what we are referencing, does also make the claim that he made steps to make sure that his conversation was private, and that that was what he was attempting to keep private. On the contrary, Mr. Denolf did not attempt to keep his actions from being seen private. The window was open.
Did he do that by going to a wooded lot 900 feet away from the public road, this isolated area? Wasn't he taking steps to ensure some privacy?
No, Your Honor, we would contend that he did not take those steps. First of all, while definitely he was 900 feet away from the nearest road, this does not mean that the evidence which he's seeking to suppress under the Fourth Amendment, namely the evidence of the plants that were seen, those were not covered. While he may have been off camera, the evidence which he's attempting to suppress was not covered.
Mr. Denolf wasn't trying to suppress the plants, correct? Those were his stepfather's plants.
Well, yes, Your Honor, those were his stepfather's plants. My understanding, however, is that since he is the only one counsel in this case, that he is the one seeking for the suppression of evidence. We would further contend, however, that there were other steps, noticeable, obvious steps that he should have taken. For example, had he merely closed the window or in some other ways prevented it from being seen, then he would have a subjective expectation of privacy.
Counselor, so you're telling me that if I'm in my home, which is 1,000 feet off of the nearest roadway, and I lift the shade in my living room, I therefore lose all expectation of privacy I have in my home?
Your Honor, I see that my time is coming to a close. May I briefly
Please
answer
do.
the question? Yes, Your Honor. We would contend that, first of all, because it is your home, and second, because it's in a residential setting, which this Court analyzes in Kearney, that there is a definite distinction which Mr. Denolf may not claim here.
Was this property not considered residential property?
May I answer the question, Your
Please
Honor?
do.
Yes, Your Honor. This was not considered residential property. First of all, while it was owned by the Denolfs, it is on the outskirts of city limits. We may assume from this that it is not zoned residential, nor were there any actual homes within the area. Thank you.
Thank you.
All right. Mr. Chief Justice, Associate Justices, and may it please the Court, my name is Joshua Kamakaviva-Ole, and I rise to continue argumentation on behalf of the State of Olympus. Your Honors, we urge this Court to rule that the punishment of life without parole is a constitutionally acceptable penalty for aggravated rape, even when that serious crime is committed by a minor. Your Honors, we seek to prove this in two ways. First, rape lies within a spectrum of crimes which this Court has deemed is acceptable. Second, life without parole is an acceptable penalty for a juvenile when he's engaged in the realm of sexual activity.
I'm sorry, Counsel, can you go back to your first statement there about rape falls within a spectrum of crimes which is acceptable? I'm not sure I understood what you were referring to.
Yes, Your Honor. Our record indicates 3 cases that this Court has ruled that have dealt with life in prison without parole: Solon v. Helm, Harmelin v. Michigan, and Roper v. Simmons. Roper v. Simmons makes up one end of the spectrum in which minors agreed to murder someone and they received originally the death penalty but was later reduced to life in prison without parole. This Court then affirmed the ruling of the lower court, saying that life in prison without parole was the proper penalty for their actions. This makes up one end of the spectrum, murder. The second end of the spectrum is seen in Harmelin v. Michigan, in where an adult was given life in prison without parole for possessing and meaning to distribute cocaine.
We seem to be mixing metaphors, for lack of a better term. You're saying that an adult can have life in prison for a nonviolent crime, but a juvenile can have life in prison for a murder. But I don't see how that gets you to the realm of a juvenile can have life in prison for a rape. Those two cases, independently, I think I understand where you're going with them, but they don't help you get to your median point. How?
Yes, Your Honor. This Court has ruled that minors should receive a lighter penalty for their actions than adults do. However, when we look at what's been ruled, we can say that rape is certainly much more serious than simply possessing and meaning to distribute cocaine. It's much closer to the end of the spectrum of receiving life in prison without parole for murdering someone. This places it somewhere within our spectrum of murder on the one extreme and possession of cocaine on the other, even though the possession of cocaine was done by an adult.
But isn't the evolving case law in our country trending towards a direction that juveniles should be treated differently when it comes to sentencing?
Your Honor, there's nothing in our record that clearly states that either states or this precedent rules towards leaning more leniently with minors when applied to rape. In cases that we have before us today, most of them deal with the death penalty, and only 2 of them do deal with rape. When we look at the cases that do deal with rape and Roper v. Simmons, these 3 cases in particular, we find an interesting trend. We find in Coker v. Georgia and in Kennedy v. Louisiana that the crime of rape is not the same as the crime of murder, but in some respects they are incredibly similar.
But those cases are adult defendants, correct? The cases that we have before us that deal with the juvenile defendant, in fact, as my sister noted, aren't we looking at them differently and saying that the juvenile should be treated differently?
Yes, Your Honor. Both of the cases that we have in our record regarding rape are involving adults. But allow us to turn our attention then to Roper v. Simmons to see the clear link between minors and sexual actions. When we look at the case of Roper v. Simmons, particularly Justice Scalia's dissent, we see his references to majority opinions of this court, 2 in particular. First, Justice Scalia notes Hodgson v. Minnesota, as this court decided in 1991, in which it decided that minors are capable of making moral decisions. In that case...
It would seem to me, counsel, I don't mean to interrupt, but that Roper really hurts you, in that in Roper we certainly held that the death penalty is not going to be extended to minors, but we also held that minors are of a different category, that they're not mature, that they're not developed, that you can't rule them out of rehabilitation. So it seems that what we've stated in Roper really favors Denolf here.
Your Honor, you brought up 2 particular points, both of which I'd like to address. The first deals with minors in terms of getting a lenient penalty because of mitigating factors. They're just different from adults. The second deals with an interest in rehabilitation. To answer the first question, as for mitigating factors, Roper is very clear that minors have a lack of understanding of their actions, but all of that is applied outside of the uniquely adult aspect of rape, a uniquely adult aspect which involves sexual activity. In Roper's...
Where do we find a distinction in the case law that says that we have to look at rape as an adult act and not one of youth?
Yes, Your Honor. When we look at Justice Scalia's dissent in Roper v. Simmons, we see him citing this Court's decision in Hodgson v. Minnesota in 1991. In that case, this Court ruled that minors are able to make moral decisions when it comes to sexual activities, in that case, like abortion. It also cites this Court's decision in Roe v. Wade, in where a similar thing was held. In the particular case, a unique case of rape, we have something that doesn't appear in the rest of the opinion of Roper, which is not just someone murdering someone, which could happen with an adult or a minor acting as a minor, foolishly perhaps, but a uniquely adult situation. Minors do not, or at least should not, be openly wanting sexual activity. What we have in Roper v. Simmons is a reference to cases where minors are acting as adults and should receive the same punishment as adults. The ironic...
Isn't the sentence that he received disproportionate to the crime as it was in Solem v. Helm?
Your Honor, Solem v. Helm, if I may quickly address the facts of the case, was a three-strikes law which was tried to be legitimized by 7 nonviolent crimes, a seeking of the government to make the case fit the law. That, in minor minutiae, doesn't actually apply here. But when we look at the proportionality standards set in Solem, we find that the interest then is to apply our standards of justice based on how other criminals in other jurisdictions are viewed and how, as a whole, the other states are tending. None of this information is really provided in the record. We understand that at the time, only 10 other states have something more or less near what Olympus has. But we're not given any idea of whether this is an upgoing trend or a receding trend or something that's stagnant. The record is simply unclear. But what we do know is that this Court has unilaterally and uniformly held that when engaged in sexual activity, minors are treated as adults.
Why shouldn't we give deference to the people of Olympus? They voted on this. They put it on their ballot, presumably, and they majority-wise voted that this is the punishment for this crime. Why should we overturn the vote?
Your Honor, we should certainly uphold the ruling of the people of Olympus, and for that reason, we're arguing that he should receive life in prison without parole.
Seems if I'm following your argument, though, Counselor, about the uniquely adult aspect of the offense, that if Mr. Denoff had murdered his victim rather than raped her, he'd be entitled to a lighter sentence. How does that serve your purposes here?
Your Honor, the record is unclear what happens to all adults or minors when they commit murder. We do know from the record that some people who commit murder receive life in prison with parole. We are not sure about whether some people who commit murder get the death penalty or life in prison without parole.
Well, is a murderer less likely to be rehabilitated than a rapist?
Your Honor, there are two aspects
Or
to this.
more likely to be rehabilitated? I'm not sure I follow you.
Your Honor, the record is unclear, again, as to what the case for murderers is. If we look at our case law, we understand that there's times in where adults who commit murder can be rehabilitated. We understand that there are times when minors can be rehabilitated. But we also have the odd case of Roper versus Simmons, in where several minors agreed to murder someone, demonstrating their will in accepting their punishment, and they received life in prison without parole. Though we're not entirely sure what Olympus says, we do know what this court states.
But we don't have the same facts as you had in Roper, where the juveniles involved in that case were clear that they understood as juveniles that what their penalties could be. We don't have any information before us that indicates that the defendant in this case engaged in these acts, assuming that he would not receive a certain penalty, correct?
May I answer the question? We're not given the same sort of testimonial opinion that we receive in Roper, in where the minors clearly stated, we are going to do this because we know we can get away with a lighter penalty. But what we do have are 5 stated felonies in a 24-hour period, which on their own may not solidify the nature of Mr. Denoff, but they certainly go towards not desiring rehabilitation.
Thank you, Counsel.
Thank you.
From the respondents.
Mr. Chief Justice, and may it please the Court. My name is Jenna Lawrence, and I, along with my co-counsel, Rachel Heflin, represent Mr. William Denoff, Jr. in this case. we ask the court to rule that police must obtain a warrant when using electronic sense-enhancing technology to obtain information from a constitutionally protected area that is not otherwise available from a public vantage point. Now, first, we need to look at the difference between naked eye surveillance and electronic sense-enhancing surveillance, as this court discussed in Kylo. Second, we need to see that this is indeed a constitutionally protected area, as laid forth in California versus Carney. And finally, we need to examine the differences between public vantage points and private vantage points, as laid forth in Florida versus Riley. Now, this court has consistently held that visual observation is not a search. However, it has done so only using the naked eye. We see this in cases such as Minnesota versus Carter, Brigham City versus Stewart, Oliver versus United States. All of these cases use naked eye surveillance. However, according to Katz versus United States, electronic surveillance necessarily requires a warrant. The cases most analogous to this case here with the use of electronic surveillance are Kylo versus United States, Katz versus United States, and United States versus Caro. In this situation, the police used an electronic piece of equipment to conduct a search on Mr. Denolf's home.
But the police are entitled to use devices, are they not? They could use binoculars, they could use cameras, I would assume. So why not extend it to a readily available device that any member of the public could purchase?
Your Honor, to examine what the police can and cannot use, we need to look to this court's test in Kylo versus United States, that of the general public use doctrine. This test has two prongs. The first prong is it available to the public? The Cyclops passes this test. The public could indeed access a Cyclops. However, it fails the second prong of the test, whether the public had a reasonable expectation that such a device would be deployed near their home. In this situation,
Are you suggesting that Mr. Denolf would have to know about the mere existence of this device in order for the police to have used it, that it's a subjective?
Not this device in particular, Your Honor, but that Mr. Denolf would expect that people standing 900 feet away from his property would consistently look into his windows. And when a device fails one of these tests, Kylo then asks us to look as to whether that information could be available from some other public vantage point. In this situation, we see that the facts of our case state that this information was only available using the Cyclops, and from no other public vantage point could the naked eye see this information. Now, secondly, we need to see how this is indeed a constitutionally protected area, as laid forth in California versus Carney. Opposing counsel did not argue that it was a vehicle, but if we look to California versus Carney, we see that recreational vehicles must be defined either as homes or as vehicles. Under the vehicle requirement, there are two prongs. The first is that it must be traveling on a public highway or immediately capable of such travel. In this instance, the recreational vehicle was not traveling on a public highway or immediately capable of such travel.
So you're saying as a result it needs greater
Yes, Your Honor.
protection?
It does. Furthermore, the second...
I'm sorry. Wasn't the weren't they attempting to register the vehicle?
Yes, Your Honor, and that we can look at the three tests that is laid out for whether it would be considered a home. There are three parts, and if a recreational vehicle meets any one of these parts after failing the vehicle test, then it is to be considered a home. The first is that it must be actually licensed, which in this situation, while they had pursued a license, it had not been granted. The second is that it must be connected to public utilities, which it was in this situation. And the final requirement is that it must be at a distance from a public road.
Even if we accept your argument that the RV is a home,
Yes, Your Honor.
the police still had a right to search the home given the exigent circumstances, didn't they?
Your Honor, the police did not have exigent circumstances prior to the first use of the Cyclops. In this court's decision in Brigham City versus Stewart, it establishes that exigent circumstances must occur before any search occurs. The police in this case saw through the window of the recreational vehicle plants growing. At that point, they went and got a warrant, and at that point saw the bloody nose of the minor child. However, before the initial search using the Cyclops, there were no exigent circumstances that would have justified this search.
What about the fact that the police had relied on an informant not only to obtain the search warrant they ultimately got, but to be there in the first place to do the drug task force surveillance? Doesn't that make any difference?
Your Honor, that means that the police had the right, as we would agree with petitioners, to sit on the public road, to observe people coming and going, whatever could be seen from the public vantage point. However, the question before this court today is whether the use of the Cyclops without a warrant is constitutional, and that use was not constitutional. Respondent is no way arguing that the police did not have any opportunity to investigate Mr. Denoff or his family.
If the police could have seen it with binoculars, would that be constitutional?
Your Honor, in this case, they could not have seen it with binoculars. And that
But if they could have?
if they could have seen it from a public vantage point, yes, Your Honor.
So are you suggesting that the court should refuse to look at any advantages or advances that we make in technology and allow police to use those advances in technologies in doing their job?
Not at all, Your Honor. We are asking that the police be granted every opportunity to prosecute those that are indeed breaking the law, while also protecting the important Fourth Amendment rights of its citizens. We need to look at how this court has differentiated between public and private vantage points. In Florida v. Riley, this court held that a surveillance was permissible that moved the police from a public vantage point, the road, to another public vantage point, above the greenhouse. However, this court has held that when technology moves the police officers from a public vantage point to a private vantage point, this is not constitutional.
But given the fact that at the time the police were there and this particular incident occurred, if my memory is correct, counsel, they in fact had secured the warrant at that point, correct?
After the second use of the
After the second
Cyclops.
use, and on the day that, in fact, your client was alleged to have committed these acts.
Yes,
They
Your Honor.
had a search warrant at that point in time, correct?
Yes, Your Honor, that is correct. The question before the court today, however, is about the use of the Cyclops before that warrant was obtained.
But doesn't the fact that when the police entered the RV and discovered the victim, the fact by that time they had a search warrant, isn't the discovery of the victim incident to the issuance of the lawful search warrant? Shouldn't that be persuasive enough?
No, Your Honor, because at that point we would be looking at the fruit of the poisonous tree. An illegal search was initially conducted with the Cyclops. Based on that information, as our record states, the police then went, garnered a warrant, entered the recreational vehicle, but that warrant came from information that was gained by violating the Fourth Amendment rights of the petitioner, the respondent in this case. This court has ruled in Kylo v. United States that when the police moved from a public vantage point, the street outside a home, to seeing thermal images from a private vantage point inside the home, this was unconstitutional.
But here we're not looking at thermal images. We have the police looking in what is really an open window.
That is correct, Your Honor. However, we do have an expectation of privacy that was demonstrated by placing the RV 900 feet away from any public road. The respondent has essentially created a curtain of darkness around his road. This court, I apologize, around
Apparently
his...
there wasn't a curtain of darkness around the road because it could be seen from the road and the police could see from the road enough to look in the window. It wasn't like there were trees surrounding it.
Your Honor, the police could see the recreational vehicle from the road with their naked eye. They could not, however, see what was inside the recreational vehicle. They moved from the public vantage point of outside the recreational vehicle and used electronic surveillance to enter the private vantage point of inside the recreational
When you
vehicle.
suggest it's electronic surveillance, in fact, the Cyclops is more of an enhanced binoculars, are they not? Because they were not using the other pieces of the equipment that they could use. They weren't there to record or
Your Honor,
do surveillance.
the record states that all information was indeed recorded. Furthermore, it was at 6:30 in the morning in January, which would assume that there's a possibility that the night vision was also being used. This was indeed an electronic piece of surveillance. We would ask this court to rule that police officers must obtain a warrant when using electronic surveillance to enter a home and conduct a search there. Thank you.
Thank you.
Mr. Chief Justice, and may it please the Court, my name is Rachel Heflin, counsel for the respondent, William Denolf, Jr. Today, we ask this Court to rule that sentencing a juvenile to life in prison without parole, without the consideration of mitigating circumstances, is a violation of the Eighth Amendment's prohibition against cruel and unusual punishments for two reasons. First, because the life in prison without parole sentence is more analogous to the punishment of the death penalty in the nature of its permanency. And second, because applying life in prison without parole, without considering mitigating circumstances to a juvenile, serves none of the purposes of the justice system, namely rehabilitation, deterrence, or retribution.
So there's no argument that the actual punishment of life in prison without parole is a cruel and unusual punishment. It's Denolf's position that simply mitigation factors have to be taken into account.
Yes, Your Honor, that is correct.
And if mitigation factors were taken into account and the result of the punishment was the same, there would be no argument that Denolf would have?
That would be true, Your Honor. At that point, it would fall to the state legislatures to determine how best to weigh out the goals of, for example, rehabilitation and deterrence. There may be an instance where they have decided that someone is not going to be likely to be able to be rehabilitated. However, according to this Court's analysis of Roper v. Simmons, as a category, juveniles are generally to be considered as targets of rehabilitation,
Counsel,
which
wasn't
is...
he already given an opportunity at rehabilitation twice?
Your Honor, the record states that the rehabilitation that Mr. Denolf was given took the form of only 4 weeks in juvenile boot camp, which is very, very minor. Mr. Denolf escalated from committing very minor crimes to a more serious crime, but he was not given any actual opportunity for true rehabilitation in the meantime. Only 4 weeks is very minimal, and the jump from that to committing him to life in prison with no chance for review or opportunity for parole is by nature extreme.
Why shouldn't the gravity of the offense be considered the key mitigating factor in this case?
Well, Your Honor, it should certainly be considered, but his youth should be considered as a main mitigating factor. This Court held in Roper v. Simmons that youths should be placed in a completely separate category from adults, namely because they are not only more susceptible to negative influences and peer pressure, but because they also do not possess the same kind of maturity and ability to make wise decisions as adults do. Opposing counsel argued that the crime of rape should fall into a separate category of offenses, and therefore that all perpetrators should be considered adults. However,
Arguing that no crime could ever hold with it a mandatory sentence. Because if we're going to have mitigation play a role in all sentencing, then isn't that inconsistent with a mandatory sentence that doesn't take, this is the crime and this is the punishment?
Your Honor, it would, which is why Respondent is not asking that mitigating circumstances be a required consideration in all cases. But because of the peculiarly permanent nature of the sentence of life in prison without parole, that sentence should not be mandatorily applied to juveniles. This Court in Solem v. Helm examined the nature of the life in prison without parole sentence and held that it varied vastly from the sentence that was upheld by this Court earlier in Rummel v. Estelle. In both cases, the defendant was sentenced to life in prison, but the Court in Solem noted that Rummel would be up for a parole review in only 12 years. The Court in Solem held that this placed him in a completely different category for evaluation than the defendant in Solem v. Helm, who was sentenced to life in prison without parole. Hence, we find that the inclusion of the opportunity for parole actually places it in a separate category of punishments from all other sentences of varying lengths, making it more analogous to the death penalty. This Court in Eddings v. Oklahoma found that it is the permanent nature of capital punishment that separates it out from all other punishments. Life in prison without parole similarly possesses a permanent nature, and considering the review, in fact, that those who have been sentenced to life and death can receive, it places Mr. Denolf in the position of suffering an even more cruel and unusual punishment, since those who are sentenced to life in prison without parole will never have the opportunity to have their sentence reviewed before it is carried out.
This defendant had a fair trial, he had legal representation, and he's had an extensive review of his trial and his sentence. Why shouldn't we consider that sufficient constitutional protection?
Well, Your Honor, the facts of the case in the record clarify that Mr. Denolf was certainly not given adequate counsel. His trial in its entirety lasted only one day. His counsel gave no opening statement, and the closing statements barely took up 3 pages of the record. But the
assistance of counsel argument, that doesn't get you into the Eighth Amendment constitutional argument.
What it does, Your Honor, is it shows the justice that is given more to the recipients of capital punishment than the justice that is given to those who are mandatorily sentenced to spend their life in prison without parole. Considering the permanent nature of both sentences, both should be able to receive more extensive review before being forced to carry out their punishments. Particularly, however, we find that considering the nature of youths and juveniles in that category as examined in Roper v. Simmons, mandatorily sentencing a juvenile to life in prison without parole does not fulfill any of the goals of the justice system: rehabilitation, deterrence, nor retribution.
So are you suggesting that the court could not have sentenced him to life in prison, or that just this particular statute is unconstitutional? But the court could have the discretion to do it, but the statute making it a per se sentence is unconstitutional?
The latter, Your Honor, that the statute itself is unconstitutional because it is a mandatory imposition of life in prison without
But given
parole.
the atrocity of this gentleman's offenses, the court could have sentenced him to life.
Potentially, Your Honor, yes. But what the Proposition 417 requires is that the courts not take into consideration his youth. This court found in Roper v. Simmons that juveniles possess very transient natures, and they referenced their earlier decision in Johnson v. Texas to hold that this transient nature and the ability for a youth who begins on the wrong foot, so to say, can in fact be rehabilitated is especially true for those under the age of 16. William Denolf Jr. is in fact only 15 years old.
The trouble I have, counsel, though, is that this court has ruled already that life without the possibility of parole is acceptable for juveniles in the murder context. And now you're trying to convince this court to say you shouldn't institute the same penalty in an aggravated rape context, which I believe I heard your opposing counsel argue was very similar to a murder. So how do you get around Roper? We've pretty much already decided the issue.
Well, Your Honor, we actually find, based on this court's analysis in Kennedy v. Louisiana, that sentencing someone to that giving someone the same sentence for the crime of murder and then mandatorily giving them the same sentence for the crime of rape actually voids the goal of the justice system in deterrence. Louisiana v. Kennedy found that under the Louisiana statute, perpetrators of rape were automatically sentenced to life in prison without parole. Similarly, those who committed murder would receive those who committed rape were sentenced to death. Similarly, those who committed the crime of murder were also sentenced to death. The court found, however, that this had no deterrence upon criminals who were considering committing the crime of rape. In fact, it was more in their interest to murder the victim and silence any possible witness who could speak out against them. Similarly, we find in Eddings v. Oklahoma and now in Roper v. Simmons that the highest penalty a juvenile can receive for committing the crime of murder is life in prison without parole. Therefore, applying the reasoning in Louisiana v. Kennedy, we find that mandatorily applying the same sentence for committing the crime of rape does not accomplish the goal of the justice system in deterring further crime.
But isn't one of the other goals of the justice system to protect the public?
Yes, Your Honor,
And
absolutely.
doesn't this, in fact, ensure that Mr. Denolf is not going to be among the public and violating other victims?
It does, Your Honor. However, as this court held in Trop v. Dulles, it should be the goal of the justice system to, in all cases possible, rehabilitate its previous offenders and return them to the society that produced them. Because of the fact that, as this court held in Roper v. Simmons, juveniles should be given the benefit of the doubt, and they should be examined to see if they are possible for successful rehabilitation. That is what makes Proposition 417 cruel and unusual on its face. There is no ability for the state to actually take into consideration Mr. Denolf's youth. They could decide, after examining the mitigating circumstances, that some individual who may be under the age of 18 does possess the mental and emotional maturity to receive an adult sentence.
What about your brother's point that sexual offenders, by the unique nature of the offense, tend not to be rehabilitated. The overwhelming evidence is in that direction.
Well, Your Honor, the evidence that was presented on that only addressed those of adult offenders, which, as Roper v. Simmons specifically addressed,
Let me finish.
thank you, Your Honor, are categorically different than their juvenile counterparts.
Thank you.
Thank
Any rebuttal?
Your Honors, I would like to begin with the arguments on the Fourth Amendment, and then I'd like to move to my co-counsel's arguments regarding cruel and unusual punishment. Beginning first of all with whether or not he has a legitimate and reasonable expectation of privacy, opposing counsel brought up that this is much more in line with the technology requirement set forth in Kylo than it is any of the other cases within our record with naked eye observation. They noted that it is the particular digital and technological and electric qualities of this technology which should give it the Kylo recommendation, namely that this is not considered legitimate under the Fourth Amendment. We, however, would respectfully disagree. We contend that the Cyclops 237's technological advancements do not provide for added collection of evidence. Rather, the electronic pieces attached to this device only serve for corroboration of evidence. The digital recording device is not used in order to obtain further information. It makes production in court significantly easier. The audio ping that is given alerting to movement within the frame does not create movement in the frame, nor does it point out anything new that could not otherwise be seen.
So why not just get a search warrant before you start the surveillance?
Your Honor, why they did not receive a search warrant, I am unsure. Whether or not it was because they did not believe they had enough evidence were unclear. However, if we do have merely a viewing from the public vantage point, using equipment which is in general...
You're suggesting it's not added collection. They needed this piece of equipment to collect this evidence. How is it not any added collection of evidence?
Your Honor, we would contend that while it may be collection of evidence, it is not some sort of illicit or illegal form of collection of evidence. The use of any sort of binocular device within the correct lighting setting could have pertained any of the same advice, any of the same information.
But the fact that they also recorded some of that, is that not an eavesdropping and something that they would normally need a search warrant for to begin with, to even use to start?
Your Honor, if this was a home setting, or if they were viewing some sort of intimate detail of the home, then perhaps they might, under Kylo. However, while it is still ambiguous, as to whether or not this was a home setting, what they determined and what they saw was knowingly made available to the public, which Katz declares, even necessarily in a home setting where one has a reasonable expectation of privacy, that is not protected.
Can you speak to the other prong of this case that opposing counsel has raised, that mitigation really must be considered here?
Yes, Your Honor. We would contend that while mitigating factors are necessary in certain cases, they may be glossed over and may not be included under certain circumstances. In the case of a sexual assault, we have individuals who are making claims that, frankly, well, they're making adult crimes. As my co-counsel stated, it is a uniquely adult offense, which we believe should...
Why is it uniquely adult? They're whether a child is 12 years old, they can engage in those activities, sexual activities.
Yes,
Why
Your Honor,
is it a uniquely adult offense?
Yes, Your Honor. I see that my time is coming to a close. May I briefly answer the question? Thank you, Your Honors. Moot contends that while an individual, possibly who is 11 or 12, may be tried for this crime, in Harmland v. Michigan, in footnote 11, we find that we need not examine all of the, quote, horrible possibilities, end quote, that may arise. Rather, we have, in our situation, a 15-year-old who not only raped his victim, but repeatedly raped her, showing that he has no desire for rehabilitation. Thank you.
Thank you.
I guess we're stuck up to you. Yeah. No, there's nothing here.
Let's take a walk. We don't walk and decide.
We're going to, before we announce the result, we traditionally like to both praise and perhaps offer some constructive criticism of the participants, and I think we'll start from my left and proceed to my right. How's that sound? Tina, want to start?
Well, I really enjoyed watching this argument, as I enjoyed the arguments all day, and congratulations to all four of you. It's an incredible amount of work and dedication, and I can appreciate that. I really don't have any negatives to say about anybody. It was very difficult for us to reach a conclusion, but we did, and I just really enjoyed it, and I was very impressed by the arguments and your backup of your arguments.
I have nothing negative to say either. Just very impressive and good job. And it's sometimes hard to believe that you guys are college students and not lawyers who've been doing this for 10 years. You're excellent. Your coaches should be proud of you.
Are you going to skip, or are you going back to you?
I always get the last word.
Yeah, get the last word. I would just sort of agree with everybody, and having done appellate work myself also for some time, you did do an amazing job, better than a lot of lawyers I've seen, sort of answering questions and responding to questions. And you had a couple really tough points to try to make arguments here to sell, but it's all you had, and folks did an amazing job, and I think were impassioned on behalf of your clients when you were making your arguments. It didn't come across as just, I've got to do this and it's my case. It was as you really believed in it, and I thought that was terrific.
Yeah, I agree with Margaret. Go forth and be zealous.
Yeah.
It's difficult to, at this level, to find very much to criticize. I know from my fading memory that some of you were here last year. I can't remember what the actual results were, but I know some of you were around, which I think is a testimony to your skills. Obviously, what we want you to take away from this, whether you win or lose, is the idea of developing your analytical and your argumentative and your presentation skills. You're all very good at that, particularly in fielding hostile questions, because you're able to confront the question rather than try to evade or sidestep it, which, as you probably know, no judge worth his or her salt is going to be very happy with that type of thing, and none of you did that. The other thing is that your knowledge of the case law and how to distinguish cases that may not be in support of your position from the facts of the current case that you're being challenged on is very good, and something that you're going to find very useful as you go on in life, whether you become attorneys or whether or not you use these skills in other walks of life. So I think you've done a very good job of it, and even if to the side that didn't prevail today, whoever that may be, the idea is to continue to hone those skills and realize that you should be very proud of the level that you've reached already, because clearly we're all very impressed with it. The only comment I would make is I think that might have been you, Joshua, about the Roper case. Don't tell the court that a decision we made was odd, because the Supreme Court of the United States doesn't ever like to be told that they've done something odd. You know, there's an old saying that we're not right because we're final because we're right. But the bottom line is that I think all of you grasped the give and take in the questioning as well as any of us have ever seen it done. So I just want to say congratulations to all of you, and good luck in the future.
Decision.
The decision we have agreed to hold for the respondent in this case, and once again, congratulations on a good effort. So first, our runners up. Aaron and Joshua, come on to the roll. And our champions. Please join us for the gentlemen. Let's come get the award for the school.
Rachel, of course, is the,
Like you're all done, you don't have to argue anyone case. Yes, sir. There you go.
Rachel, of course, is a three-time winner of this event with
Wow.
3 different partners. It's pretty remarkable, it's pretty remarkable accomplishment in that regard. And of course, the championship trophy. That's in the cup.
I'll get one with all of you in a second. No, I'll get, let me get two of you first. Here, hold on. Get the trophy. Take 2. Okay, why don't you get together with, there you go. And then I'll get one with, you want to say, it's up to you. All right, here you go.
This will be
And I
my
think it's only.
Yeah, why don't you get on the other side of the thing, and then I'll get all of you together. Okay. All right. You know what? Actually, yeah, this is good. Never mind. Sorry.